During an interview, then, I think most people would be aware that you kind of have three options, and that's to, answer questions, to give no comment, or to prepare a written statement. The question that we got quite a lot was, if I choose to say no comment, does that make me look guilty? Can that be held against me? Does it make me look more suspicious?
Yeah, so there are lots of different reasons why someone might answer no comment. Yes, it's something that you have to know, and it's part of the caution that the police will say to you about the fact that it may harm your defence if you do not mention something that you later rely on in court. Now, what that means is if you have a perfectly good explanation as to what's happened that you can tell the police on that date, but you don't tell them in the interview, and you get charged and it goes to court, the court can say, well, why? And then you're explaining that at court. The court can say, well, why didn't Oliver explain at the police station what happened? Why has he waited all these months later? Had he come up with a story? Has he made something up? That's something known as the adverse inference. So that can, and that does happen at court. But it can be legitimately explained. So there's a few different ways that we can deal with it. So sometimes at the police station, what we do, or one, as solicitors, we will record your instructions. So if you've told us your very good explanation, we can say, well, yes, they may have only said it now, but this has always been what they've said from the time of arrest, and we've got that recorded. Sometimes we even do what's known as a retained prepared statement, and we write down someone's instructions and their explanation. We get them to sign and date and time stamp it, and again we can bring that out at court later and say, here's a statement that we wrote at that time. So he hasn't made it up, it's always what he said, we just didn't give it an interview for certain reasons. There might be lots of different reasons that you've been advised to go no comment. And also that's what you can say, obviously, at court, to say, well, I was, 14 years old following the advice of my solicitor. I don't know any better. That's what most people say when they go to court. But yeah, there's lots of reasons. Maybe the evidence is exceptionally weak. Maybe, say, for example, it's like a domestic scenario, and the reality is that you were acting in self-defense. Look, often, sometimes with domestic cases, the police will say, look, it's clear that this shouldn't even be here, but we've just got to go through the motions and we're going to take no further action against this person. So a lot of the times in those scenarios, even though someone might have a defense, our advice might be, well, why are we even going to admit on record? It's for the police to prove the case. So why would we even admit on record that there's been some sort of, altercation together at all, when it's not going to go anywhere? The person isn't giving a statement. They don't want to proceed, it's not going to go anywhere anyway. So in terms of protecting you and not for some reason kind of getting you charged, let's say nothing. Of course, it's all case by case scenario, and there's not like a blanket advice that we can give, and it depends on the evidence. If the evidence is exceptionally weak, what some solicitors do, not all of them, but what I like to do is I will say on record, the disclosure. So disclosure is what we call when the police give us information about the offences. And I'll say the disclosure is very limited. And the evidence, we've been given very, very little information. And what we say to officers sometimes, if they're not giving us enough information about what they say has happened, I even say to officers, I will have no choice but to advise my client no comment, because you're not giving me any information. So how can I advise my client if you're not even giving me the dates or times of the 13 robberies that have apparently occurred? So there are lots of legitimate reasons. But generally, if you have a defence, it's best to try and put something forward. But as I say, we can't kind of give like a general advice. It really depends on a case by case basis.
So it's definitely always best to just follow the advice of your solicitor rather than kind of go in with an opinion of, I'm just not going to answer anything that the police officers ask me. It's much better if you're getting that advice from your solicitor, it's for a reason, and just sort of follow that advice.